Phineas Taylor Barnum, better known by his initials P.T. Barnum, is known as the Great American Showman because of his marketing genius. He shamelessly fabricated great wonders like the Fiji mermaid, a monkey's body attached to a fishtail, and relied on publicity stunts and curiosities to sell his circus. Once he drummed up interest for his show by using circus elephants to plow his front yard. Clever business people have known for centuries that marketing is the key to business success, but for most of the existence of the legal profession, advertising was both prohibited and viewed as vulgar and even dangerous. Some of these marketing regulations remain today, even though the strict prohibition on advertising has gone the way of the judge's wig. This is the lecture series for Ethics in the Legal Environment at the University of Mississippi. And in this lecture, we will be covering two topics on how attorneys drum up business: referrals and direct solicitations. Let's begin with referrals, word of mouth from either satisfied clients or colleagues from whom the attorney has earned some respect. One way to get referrals is to do a good job with enough clients that they independently recommend you to their friends and family. Of course, this natural growth of business takes time, so lawyers may try to engineer referrals. There are some issues to consider here. One way to engineer referrals in other professions is through compensation. Even though it might seem unseemly, it is perfectly permissible and legal to trade economic favors for referrals in most professions and industries. A mechanic might promise to buy only parts from one auto parts store if that auto parts store will send customers with busted radiators to only that mechanic. For mechanics and auto parts store owners, such an arrangement is permissible. However, generally, attorneys cannot compensate with cash, bonuses, awards, etc. anyone who recommends their legal services. It might make economic sense for lawyers to give some compensation when, say, a chiropractor refers clients who the chiropractor thinks may have had on-the-job injuries. But this arrangement is unethical for the attorney. It promotes litigiousness, and it takes away from the independent judgment of the client to decide who would be the best lawyer to handle that injury. An exception to this rule is the mutual referral arrangement between lawyers. Attorneys who are familiar with each other's services but practice in different areas are permitted to enter into an agreement to recommend each other to clients seeking those services. Say House and Associates practices in real estate transactions, while the Carr firm practices in automobile injury cases. These two law firms could negotiate to be compensated when one recommends a client to the other. These referral arrangements cannot be exclusive, and the client must be made aware of the arrangement, i.e., House has to disclose to the client that he is recommending Carr because he and Carr have an arrangement. In short, referrals are permissible, but there are rules protecting clients from being unfairly manipulated in the process. Remember referencing Danny DeVito in John Grisham's The Firm? In that film, DeVito's character has provided some incentive to the nurses in the hospital to notify him when a potential personal injury client lands in the hospital. Besides direct solicitation, which I will discuss in just a moment, this sounds dangerously close to the prohibition in Rule 7.2i, which says that the lawyer shall not give anything of value to a person for recommending the lawyer's services. So let's turn next to direct solicitations, and let's continue considering Danny DeVito's character in The Firm. In that scene, DeVito was engaging in direct solicitation. So despite the questions about whether the solicitation was misleading or not, it was definitely direct solicitation, which is impermissible. Mississippi Rule of Professional Conduct 7.3a prohibits lawyers from directly soliciting potential clients with whom they do not have a pre-existing connection. Sometimes lawyers engaging in direct solicitation are called ambulance chasers because they descend upon an injured person and try to directly solicit them to sign up as a client very shortly after an accident. The bar rules against direct solicitation exist because such contact often exerts pressure upon the injured person and requires an immediate response from the recipient without providing time for comparison or reflection. Much as an attorney challenged the advertising prohibition in Bates v. Arizona State Bar, another lawyer challenged the direct solicitation prohibition in O'Reilly v. Ohio State Bar. In that case, the U.S. Supreme Court found that lawyers do not have a First Amendment right to direct in-person solicitation of clients. Reading Bates and O'Reilly together, we can surmise that lawyers have some First Amendment free speech rights in commercial solicitation, but that those rights have limits. Another case dealing with direct solicitation is Mississippi Bar v. Turnage, in which the Mississippi Supreme Court said, "Solicitation has never been recognized as beneficial to the profession or to the client. It has the potential for creating litigation, creating fraudulent claims, and turning our profession from one of service to one of profit. Solicitation can result in a diminished status for the lawyer and be harmful to the profession's reputation." The rules recognize that lawyers can approach their friends, family, and others who have pre-existing connections with offers to provide legal services, but the rules prohibit direct solicitation to persons with whom the lawyer does not have a direct personal connection. And because of the concerns outlined in Turnage, there exists in most jurisdictions a complete ban, even for friends and relatives who are lawyers, on soliciting clients for personal injury or wrongful death claims in the immediate aftermath of a serious injury or death. A final point about advertising and solicitation. Recall that such advertising and solicitation cannot be misleading. It is generally accepted that alleging to be a specialist in any particular legal field would be misleading without some factual basis to back up that claim. As a result, bar associations and legal trade groups have developed curricula and programs for recognizing achievement in certain legal fields. The American Bar Association, for example, has an accreditation program for many fields in the law. So a lawyer saying that he is a specialist in domestic law may be too vague and may be misleading. However, if the lawyer says that he is accredited in domestic law by the American Bar Association, then he has made a concrete, verifiable claim. To review this whole unit on advertising and solicitation, remember that advertising is a relatively new aspect of legal practice. Having been approved by the Supreme Court in the Bates case, it is now permitted and regulated by the state bar associations. While it is permissible, it still must not be misleading. All bar associations have protocols whereby attorneys pre-submit proposed advertisements so that the bar can verify that they are not misleading. Beyond advertising, lawyers may use referral systems, but they may not engage in compensation for those referrals. And generally, direct solicitation of clients is not permissible. In this series, we have covered a great many regulations and prohibitions in the profession. Ultimately, most of these regulations are imposed on lawyers by lawyers via the state bar associations. So we are a self-policing profession. What that looks like practically is the subject of the next unit on maintaining the integrity of the profession. Until next time.